Cool. Welcome everyone. I think we're on time, aren't we? Yeah, all good. Let me just put a few bits into the chat and whatnot. Hey, right. Welcome back, Will. So, one more thing I've got to do. I've muted myself, which is progress, isn't it? There we go. So, cool. Right. Yeah, cool. Welcome everyone. Hope you've had a reasonable week. I'm not sure if anyone caught the Northern Lights last Thursday. We did in Bedford. It was quite nice. And I just didn't quite get a comment this evening, which is why I'm a bit flustered because I'm running late. But yeah, cool. Usual stuff. This is not legal advice. It is us trying to be helpful. But yeah, we just don't know enough about your situation to actually give anything that's definitive. And also, please don't put any personal data in the chat. And what I mean by that is if you ask a question about yourself, that's going to be personal data. So make it out as if it's a what if question about a hypothetical situation. That way you'll get the same answer, but you won't have to put your personal data onto the internet to get an answer. So we've got two questions in, unless I've missed any for tonight. So it could be a really short night, which is cool because my voice is going and I've got training tomorrow. So we'll see how that goes. But yeah, if you want to give it a like and share, that would also help me out a little bit. But if there's not, well, there are actually a couple of notices. So interesting case from the LGO this week. I have not read it at all, really, other than just seeing what the headlines were. But I'll get it up and running here. So you should see it. Is that what you seen the right one there? You seen? Yeah, cool. So let's go back up to the top. So it's Tower Hamlets, which is a pretty bad council. So it's not that surprising, I guess. But basically, what is interesting that I did see was that it kind of takes into account the adult social care as well, and how they fail to work with housing, and basically there's a whole string of problems all throughout, and they get something like 10 grand in total, so 8.5 grand to remedy the stress and worry. So we had a significant health issues and disabilities, and another sort of 1,500 there just about some other stuff like removal cost, storage cost, that sort of stuff. So yeah, I mean that's yeah, probably quite a lot in there. Shame I didn't read it properly, but there's yeah, just check out. So if I just go back up to the top, if you search for this code here in the LGO website, you'll find it. So yeah, that's that. And I've also got a bunch more responses in from the average housing register waiting times. So I'm just going to scan through it. If you want to have a little look, see if your council pops up. Yeah, there's over 100 now, and I think there's a week left that they've technically got to respond. So if I just go through it, you can kind of pause it. You'll notice that some of them are basically, if they don't say otherwise, they're in days. Not converted them all yet, so some of them in years and months and stuff, but it does say in weeks as well. Nothing else particularly interesting other than the fact that Great Yarmouth, they also provided figures for the total wait, and what that shows is that people are certainly waiting a lot longer than 2 months before they get a decision. So I'll have to factor that in as well when I kind of get to actually sort of look at all of this. But anyway, so yeah,
Can I
yeah, go on.
there was one there that said proper stupid response in the notes, and I'm just wondering,
Yeah, I'm
are
happy
they
with
written
that. It
that down a
was,
bit?
yeah, I know what you mean. I think it was
There we go.
Basildon somewhere. This could be.
Stop. It was in the S's.
Well, yeah, there's stupid response of
Oh,
Basel.
there's a
I can't
couple of
remember
there.
which one was. Yeah, but yeah, so basically Basildon were like, oh, we can only do an average, and that's some people get housed really quickly, and some people take longer. And I'm like, yeah, that's what an average is. That's what I want, and I just couldn't be bothered to argue with them. So yeah, I've not
Right.
yet got any figures from them. I can't remember what the other one was. Let's have a proper stupid response.
Stockport.
Stockport. Um, yeah, so this is what they said. Due to operating a choice-based letting system, it's not relevant to state average waiting times as customers, oh, I don't even know how to read the rest of it. I can read up there, have the ability and choice to bid on for any properties. I can know that. That's why I want the average. I don't, that's anyway. Yeah. So, anyway, yeah, there we go. So, yeah, you'll see more of me talking about that in coming weeks as I get more and more of the answers. But yeah, let's get on to a few bits and pieces. You're right, Cheeseface. You're right, Ramilla. So the questions we've had coming through the week are dead easy. First one is, and let me just line up the old virtual flip chart here. Zoom in a bit. Um, before I go on, any gossip from you guys? Shannon, you were saying about Museum of Homelessness. Do you want to talk about that?
Yeah, I mean it's a bit depressing. So, actually, if you guys just want to go find it yourselves, But essentially, Museum of Homelessness have come out with some research, and the stats for people experiencing homelessness and death is ridiculously high. I think it was like 42% increase with rough sleeper deaths. And I think like a 12% increase in all sorts of forms of homelessness. And it goes into much more detail about like fatalities and how they've got the data and everything else. So I guess it's just we do this live stream, and it sometimes I'm like, are we actually helping or what have you? And I think well, actually people are dying out there. And when we come harshly on housing officers for making stupid decisions or whatever, like this stuff matters. And I'm not saying everyone is at risk of dying, but um, the reality is, I think homelessness affects often the most vulnerable of our society, and as a society, we're not doing enough to protect them. And that was a bit of a rant that I didn't expect to go on. So yeah, the research is out there.
Yeah, cool. And you mentioned Rick Henderson, who's chief exec of Homeless Link, is talking about like some sort of review when someone dies when they're homeless, which we've been pushing for in Bedford for many years. Didn't get very far, so hopefully someone like Homeless Link can get further than we did. So yeah, cool. Right. So questions for this week. Here's the first one. How long uh how long does it take to hear from the ombudsman to know if they would investigate your case or not? So there's no kind of set time, but in my experience, it's going to be a couple of months. So bearing in mind that by this stage, you've already exhausted the council's complaints process, which can take months. You then complain to the local government ombudsman, and as I say, I don't remember it ever being more than like 2 months before I heard from them. But then they then investigate, which can take another 2 months or so, sometimes longer. So it's not going to be a quick outcome, which is, I guess, one of the main downsides of the LGO as being a way of getting a bit of justice. But yeah, that's the kind of ballpark figure anyway. So if anyone's kind of had any different experiences, say it on the chat. You guys can feel free to interrupt me if I've kind of, yeah, if you want to say anything else. But if not, the other one, where's the chat gone? There it is. The other question is nice and easy as well. Is an approach the same as an application? And the answer is yes, it is. It's just a bit of jargon. So when you look at the Homelessness Code of Guidance, it basically says people can approach any department of local authority and make the application in any particular form. So that is just the approach is the act of you going to a council and asking for help with housing and giving them reason to believe that you might be homeless. So it's the same thing, really. You'll notice that in a lot of the kind of council systems, and if you ever do a subject access request, you'll see that kind of terminology. The difficulty might be that some housing officers don't actually realise that it means an application. So whilst you may well have triggered an application, they might still be gatekeeping and just messing around, basically. So, but yeah, it's yeah, that's what the terminology means. So, let's get into the old questions on the live stream then. So, there's a two-parter here. Oh no, three-parter. Let's get it lined up all up before we start delving into it. By the way, putting the dot is helpful because it does alert me to the fact that's what's going on. So thanks, Rumina. And then there's one more bit, I think. So yeah, so I think that's it. Oh no, there's a bit more. No, there's okay, right. There's quite a bit more. I mean, I know what the answer is already. Yeah, so basically, let's read it all out. Here we go. Cool. So yeah, so what if someone has been given Section 21, they're a family in priority need band A, they apply to the council, however, the council is insisting they wait for the bailiffs, even though they showed the housing officer the code of guidance that it isn't necessary to wait for the bailiffs. They showed the council officer the code of guidance, however, the council officer says that they still have to wait for the bailiffs, otherwise the council can't assist them. They managed to get this conversation via email, excellent. And the council officer even challenged them that if they're not happy waiting for bailiffs, that they insisting the family stay until bailiffs come, and then they can claim council will help. But for now, the council are refusing to help any form of temporary accommodation, yet they're due to be evicted in 2 weeks from now. What should they do as the council has been stubborn and challenging them to report it? So yeah, basically the answer is a complaint, and the problem you've got is the complaint won't actually fix the situation in the short term, but it will probably lead to a compensation claim down the road. Let me think. Let me see if I can dig out an LGO decision. I think I know where one is. Which basically, there's loads of them now. They're happening all the time. But if I just go to, um, here we go. So it's probably gonna. So oh, it's one of these two basically. Let me just put this in. So I'm going to put it into the live stream chat. Yeah, this is one from Brentford, and there's one from Islington, and one of them is where a landlord claimed compensation in this situation, and one is where a tenant claimed compensation. So basically, read them both or look at them both, and you'll see that's how the LGO deal with these kind of situations. I'll also put the hold on. Let's be even cleverer. So I'm also putting the video I did about this. Now, this person, Ramila, you might already seen this to be honest, but just in case you haven't, here's the video on the channel where I talk about it in more detail, and yeah, hopefully answer that question because in one sense, it just seems to me that Milton Keynes probably doesn't get challenged very often. They have got ridiculous caseloads. That's something we found out early this year. They had a average caseload of like 177, which is impossible. So yeah, the answer is you complain to the chief exec, quote the code of guidance, and you want to be kind of a little bit pedantic. So if we just bring the code of guidance up, just so we can see what we're talking about here, which means I need to open the code of guidance. So it's 6.35 to 6.38 you want to be looking at. Here we go. Sorry, my screen, I've just got to juggle everything around. Let's get rid of that, zoom in, not that much, and then 6.35. Nearly. Let's go to the next one. There we go. So let's just go through this again. Let's just pick this apart just for the benefit of just kind of, it is a little bit complicated. So 6.35, the Secretary of State considers that where an applicant is an assured short hold tenant who has received a valid notice in accordance with Section 21 of the Housing Act 1988, the housing authority is satisfied that the landlord intends to seek possession of further efforts from the housing authority to resolve the situation to persuade the landlord to allow the tenant to remain in the property are unlikely to be successful. So I'm assuming that's the case in the question we've got here tonight. And there would be no defence to an application for possession order. So again, you need to know for yourself whether there would be, but realistically, there probably won't be. Will or Caris, I'm looking at you. Sorry, Shannon, I know these, Will and Caris will deal with this more often. What sorts of situations is there going to be a defence? My guess is not many, but do you want to just kind of explain? Will, shall I pick on you? In what situations would there be a defence to the possession?
Shall I answer that?
Yeah,
well,
go for it.
This is to a Section 21 notice claim, yeah?
Yeah.
So stop me if I go on too long, but the and originally after 1988 when the Act came in, the only defence you had really, or that you were supposed to have, was that either this wasn't an assured short hold tenancy and a notice, the tenancy hadn't ended, or a valid notice hadn't been served. Now, those were all fairly easy up until about 2012, because then the law changed and landlords had to do all this stuff like tenant deposit protection. So if the landlord hadn't protected the deposit at the beginning of the tenancy by paying it into an approved scheme and giving the tenant proof of the payment in, and let's just say complied with various other requirements that came in over time, like giving the right to rent leaflet and gas safety certificates and so forth. So the answer is there's a number of possible defences, all based on breaches of the requirements that need to be complied with before a Section 21 notice can be valid. If you want to know more about that, then on the Anthony Gold website, there's a checklist for, and it's on the Nearly Legal blog as well, a checklist for how to spot if there is a possible defence if the notice is invalid. So there could be quite a lot. It's very easy for the landlord to get it wrong and for there to be a defence. But the council ought to check that, really, when you go in there and say, is it a valid notice? And they say, well, wait till the bailiffs come. That isn't really answering the question. They've got to actually say, we think you've got that notice isn't valid, so you're okay.
Yeah.
Does that answer?
Yeah, it does. Yeah, I think you're right, because so the housing officer should have picked up if this applied. So if someone goes to a housing officer and says, look, here's the code of guidance, this is what it says, then if the housing officer doesn't say something that satisfies B or C, then they're talking nonsense, basically. Karis, did you want to add anything to that one?
And you might hit me for this one, but it's the Homelessness Reduction Act, where it's supposed to like prevent the duty to prevent homelessness, and that's what they can also put in, because they're not really doing that and working together, statutory homeless services, and working closely, joint to prevent homelessness. So getting that in there, I think, is something that's just not used enough, although it's pretty toothless, because if you can't access it, but put it in, because then that's the thing. It's supposed to shorten that gap in preventing that. Just wait for the bailiffs, but they have a duty to homelessness reduction. Here's the statutory duty to prevent homelessness. They go for that.
I mean,
one.
there's yeah. I mean, I think that there's a bit more that also kind of kicks in here. So we've got 6.38, which basically says should ensure homeless families and vulnerable individuals who are owed Section 1.8 interim accommodation duty are not evicted through the enforcement of an order of possession as a result of a failure by an authority to make a suitable accommodation available to them. So, yeah, I mean, it's pretty unequivocal in that sense. Let me just bring up the decision I was talking about. So it was the Islington one, I think. Yeah. So now, I would need to read this all again. I haven't read this for months, but you'll notice that this family got £500 for every month she was left in the tenancy instead of being an interim accommodation. So in the question we've had tonight, it relates to a family with children, so they're in priority need. The interim duty applies. So in one sense, when you write the complaint to the chief exec, if it was me, I'd put in the £500 per month. So whenever the Section 21 expired till now, when the bailiff comes, and then additional 355 to cover the avoidable court costs, and an additional 250 in recognition of the uncertainty and distress or anxiety caused. So I think that's this isn't, you can't read this to be gospel. This was obviously kind of contextual in the situation of Miss X and Islington, but it's a good indicator, I'd say. So I think that's your kind of ballpark, kind of what you're going in with when you write to the chief exec. And again, copying the relevant councillors and so on. So yeah. Let's see if we've got anything else in relation to that. So
there's a couple of follow-ups around sort of like how to write the complaint, which I think might be useful, because I mean, you talk about it, Mike, about your first complaint being pages and pages long, and actually it not necessarily being necessary, and just making it really clear of like, here's the situation, here's the failings, here's what needs to happen, and sort of laying it out quite clearly and keeping it quite factual. So again, if you're imagining it as happening it to someone else and everything else, and even getting, if you've got a friend who can sort of help you wade through, so you're not making it personal, you're not saying the housing officer made me feel like this, it's just this is, the chain. And I think, I mean, yeah, if it was me, I'd probably include the email chain as well. You can sort of save it as an attachment and add it to the complaint.
Yeah, I mean, I'd write a complaint something like, "Dear Chief Exec and Councillor X, whatever, outline the situation in a couple of sentences. I'm currently a tenant, received a valid Section 21 notice. Approached Milton Keynes Council. Milton Keynes Council housing officer told me to stay until the bailiffs came. I quoted 6.35 to 6.38 the Code of Guidance. Here it is again. Boom. They said that didn't matter. I'm therefore asking for £500 per month that I've been in this situation for, plus the 250 for distress, plus the 355 for the court costs." And that's kind of it. As I say, the first stage complaint is not going to get upheld anyway. That's just the way they deal with things, it seems. So just essentially your second stage complaint would almost be exactly the same as the first stage. You just plow through it. I did do a video on the channel a couple of months ago, whatever, the best way to make a complaint. So I'd suggest you watch that. It's an hour long, but it does go into a lot of detail. That's how I would do it, basically. So yeah, so you've done the right thing. The other thing you might want to consider is, do you wait to make a subject access request before you complain? But I'd say in this situation, probably not. You've got the email trail already. You've got the dates that the Section 21 expired. You've got the you've got the date that the bailiff's warrant's going to come or whatever. So you probably don't need any of that additional evidence yet. And then when you get things sorted, one of the things you might want to do is raise the issue with the housing committee in Milton Keynes or full council or whatever. Just say, why are your housing officers advising stuff which isn't lawful, that leaves the council open to compensation claims. But that's way down the line, basically. So yeah, that's how I would do it, basically. Trying to think of anything else in there, probably not. It's a straightforward situation. The guidance is clear, as I say. As long as neither of B or C apply in 6.35, then there's no reason. Yeah, the LJ will uphold the complaint. It seems that seems the way it's going at the moment. There's no argument to say you might complain directly to the LGO, but I don't know. They we saw last week they do sometimes deal with urgent cases, but I don't think they're going to see this as urgent, as callous as that sounds, because in one sense you will have a roof over your head. So the one we saw last week where they investigated before the council dealt with it properly was where someone was actually rough sleeping still, so the LGO just jumped in at that point. So yeah,
this might not be relevant in this situation either, but I know for some people it might be. So throwing it out there, if you have disabilities that affect like communication methods or anything like that, I'd also outline it in the complaint. Like technically they should have access to that information or what have you, but say actually you would like it via email because you can't open letters for some reason or whatever it might be. It might be anxiety, so you don't want to talk about it over the phone, or it might, do you know what I mean? Like if you have a disability that affects the way this might be handled, it's worth just not just highlighting that, but how it will affect the complaint process.
Yeah, cool. Nice one. There's a quick question in there, unless anyone else wants to jump in. So just, well, in fact, it's just a question about the waiting times I put up there. So at the moment, that's a live document. It's not finished yet. So I'm just waiting to hear back from as many councillors as possible before it. We're probably going to put it on Will's website, but I will do more on it as we get closer. So all you can do for the time being is if you go back to the beginning of the recording, just pause the screen. I kind of left it on there long enough for you to pause it at the bit of the thing. It's not even in alphabetical order yet. So some of it is, but some of it isn't. But basically what you're looking at is, if you're in London, you're looking at if you're a single person, you're looking at sort of 4 years, just 4 or 5 years. Tower Hamlets 5 years. Single people, or 2 years in Tower Hamlets actually single people. Waltham Forest 4 years. So Lambeth 1700 days. What's that, like 6 years? 5 years. So whereas if you're in the middle of nowhere. And by that I mean Ipswich, which isn't really the middle of nowhere. It says, well, their stats were 21 days if you are a single person. Now that is after they've made the decision, which is where it gets a bit more interesting. But that's the sort of So yeah, basically it makes a massive difference. So there's no more questions we've had in during the week. There are no further questions in the live stream right now. So I'm going to give it 30 seconds, and if there are no further questions, we'll call it a night. Again, if you want to give it a little like and a share or whatever, that'd be awesome. But I think we've covered it all, haven't we? So yeah, I will give it another 30 seconds because there's that lag. So it might be that someone's frantically typing something in right now. But I don't have much else to say this week, really. Feel like there's some other stuff I was working on, but yeah, I don't know. Yeah, there's nothing else interesting I've got to say at this point in time.
Can I just plug my show on Monday if anybody is interested in asking any other questions but didn't get around to it tonight? There's I will be back. I don't think, Karis, you won't be with us on Monday, will you? You'll be away. But we should be back on Monday evening doing a live stream on my channel. Oh, there's a question coming up, I think. So yeah, and I'll try and do some reading in advance this time as well with recent cases.
Yeah, we still need to, I think the big videos we'd still need to work out is we need to do one about affordability, what about suitability in general. We need to finish the series off we did about vulnerability. So there's that stuff as well we're going to kind of factor in at some point, but it just depends on, someone just said hold on in the live chat. We're holding on, don't worry, we won't go anywhere. So yeah. Oh yeah, and also this is, I'll put this out there because I don't, basically just in case. If anyone knows of any council responses to empty homes that are quite good, let us know, because we're kind of trying to raise it at Bedford Borough Council, and we're just interested to know if there's somewhere else in the country that does it better than Bedford, which it probably is, so they can kind of go and learn from them. Basically, here we go. So someone saying haven't answered the midweek question. I don't know where that. Let me have a little look. The problem I've got is when I've got comments coming in on the channel, I won't see the names of the people asking the question. So I'm just trying to see if I can see anything that's cropping up there.
Maybe they can paste it into here.
Yeah, I mean, if it's possible to paste it, I guess that you, let's have a look. So yeah, so I generally can't see that question untouchable. So yeah, if you want to just point me in the right direction or say what day you'd asked it or anything like that, that might help me just kind of find it. Yeah, as I say, like your usernames on the live stream aren't the same as what I see on this end of YouTube for whatever reason. Oh yeah, okay, yeah, sorry. I do remember that one. So yeah, can the ombudsman investigate a case after 6 years? Yeah, cool. Yeah, I do. Yeah, sorry, apologies for that. I did remember that. I thought I'd answered it, but I haven't. So yeah, so again, Will and Karis being solicitors might be able to give more of an answer than me and Shannon can. But basically, yeah, the question is, can the local government ombudsman investigate the case after 6 years? The first answer to it is only in exceptional circumstances. So the local government ombudsman has investigated historic stuff where either the person was in just no place to kind of actually take the complaint at the time. So we've seen that before, where someone's rough sleeping or having a mental health crisis or something like that. So they just weren't in the position to raise a complaint. Or if they weren't aware of something and it's only just come to light, which I have seen an ombudsman kind of tack on something onto that. But the question of like statute limitations, I guess, comes in now. I don't know if the ombudsman is actually affected by that necessarily. They probably are, but I just wondered if Will or Karis wanted to kind of sort of give any more detail about that. So it seems that in most areas of law, statute limitation is 6 years, which means that you know after 6 years it's done. But yeah, Will, do you want to kind of I mean, I think we're talking in relation to council's failings here, if that helps you kind of hone in the answer.
The usual time limit for bringing a legal claim about anything is 6 years. That's the statute of limitations, or the Limitations Act. And there's some exceptions to that. If you're making a counterclaim for disrepair based on when you're facing a possession claim, I think you can go back further than 6 years. Somebody can correct me if I'm wrong, but it's usually less than that. For instance, if you want to bring a judicial review, you've got a 3-month time limit. And I think traditionally, if you wanted to bring, and this isn't part of our remit, but I think an unfair dismissal claim is even less, is 6 weeks or 6 months, or it's a very short time. I mean, it all
3
seems
months,
very
I think.
unfair.
Yeah, 3 months, I believe.
But the thing is, with most of these things, I mean, if you wanted to make a complaint, well, if you want to make a complaint to the ombudsman, I think you've really got to do it very. Isn't it 12 months? They don't really want to get involved.
Yeah, and you need to. So you need to get to them by that. So bear in mind, you've got to get through the council's complaints process first, which makes it interesting.
And with a judicial review, if you fall foul of the 3 months, you can always sort of get your complaint up and running again by just making a fresh application and saying, I'm asking you to reconsider your decision, and then you'd be challenging their refusal to reconsider their decision. Some people might say that's an abuse of the system, but you know, if you're a member of the public and you're not used to bringing judicial reviews in your spare time, then the courts might look quite lightly on somebody saying, well, look, okay, I'm not going to challenge the original decision, but can you have another look at this?
I think isn't the ombudsman from 6 years, but they haven't done anything to it unless you've got 3 years of becoming aware of it as well after 6 years. But if it's just unreasonable to do so, they will look into it. Depends on what it is, and if you can advocate why you came around with it and why you're complaining now, and if it's an ongoing issue.
Yeah,
something that's still ongoing, although it was 6 years ago when it started, or it happened 6 years ago, and it's still in effect. What's it
Yeah.
now? Then you can complain about it now because it's reasonable that you're complaining about it now.
so the situation I was involved in where I saw it firsthand was where someone had been gate kept, and so we complained about that. Then we got the subject access request records back, and it turned out that she'd been gate kept 4 years before, back in like 2018 or something, 2019. This is a couple of years ago now. And so the ombudsman investigated all of it, but it was because she didn't know at the time that she'd been failed. So it was only kind of when we looked through the records and saw actually, they gate kept you at this point. So that was my only time I've seen it done, other than when there was that one, as I say, like a few weeks ago. That was kind of, again, it was someone who's rough sleeping or something, where they just weren't in a place to be raising it themselves at that point.
I think
So yeah,
it also depends, like, what the person wants out of the complaint. And obviously, potentially compensation is an option, but if you're wanting local authority remedies, actually it's going to be less likely to happen because the local authority has more of a scope to say, it's 6 years ago, we've changed our practices, all of our policies have been updated, the staff member no longer works there, or whatever it might be. So I think it's just also about like managing your own expectations about what they might ask the local authority to do, because we see in a lot of LGO cases, that they recommend, the local authority changes something or does something, and I think that might be less likely to be the case if it's been 6 years. I'm not saying it's not possible, but it's just worth having to think about what it is you're wanting from a complaint and whether you could take it to a housing committee instead, or you could contact your local MP instead, or there might be other routes to get what it is you're after, an FOI, or anyway.
Yeah, cool. Cool. Let me just get the flip chart back up. So there's just some continuation on this theme of bailiffs and stuff, which is another sensible question here. So the council would first, so they said the council would first, the council said they would first find private landlords for the family, and if they fail, they would put them on a social housing, which is 3 to 10 year wait. Is that lawful? So the answer, let me just separate these questions out. Actually, the answer is no, it's not. To some extent. So basically, even now, this person is in the prevention duty, or should be under the prevention duty, because in fact they should be under the relief duty because the Section 21 has expired. So what that means is they get something called reasonable preference. It guarantees that you get onto the housing register now. Now you might have the lowest banding, which gives you no real prospect of getting housed, but you should be on the housing register now. So if they're saying you can't go on, on the social housing list now, then that's that, again, get it in an email and incorporate it into your complaint. The issue is that they can put, if they say, okay, well, legally we've got to put you on the housing register, so we will, but you're band D, again, there's no prospect of getting housed. What then is going to happen is there's nothing stopping them whatsoever to then find suitable private rented accommodation for you. So there's no way to guarantee getting social housing, but the council can't just say blanket, well, we won't put you on the register. That's not lawful. You need to be put on the register, but it probably, the chance side that you may well end up in private rented. And again, I haven't had a response yet from Milton Keynes, but I guess we're talking here about 3 or 4 beds. I'd be surprised if it was that long. We saw someone on the live stream quite a long time ago where the council told them, it's going to be 10 years. And then they came back like 2 months later, said, I've been housed already. The council were lying about there not being any houses. So when I get the kind of the FOI back from Milton Keynes to give you the waiting time, it'll be on the Excel sheet. So keep an eye out for it. And then number 6, as we see it here, in reference to the chain of questions, they also have email conversation proof from the leader of the council telling the tenants to wait for the bailiff. So, basically that's because the leader of the council won't know the law either. They'll just be going on what the housing officers tell them. So again, it's good that you've got that proof, because the LGO will probably say something about it, and it's going to be a little bit embarrassing for the leader of the council. So but it doesn't change your approach. Your approach is still going to be to complain, and just kind of just go through it factually. Yeah, and so yeah, then you kind of make the point the questions then made. So hold on, let me stick that in there as well. So therefore, my question is: if the leader of the council is giving unlawful advice, isn't it possible they would ignore their email of complaint if the MK council officer? So what it basically does. So if you were to put that complaint together, where you kind of cite in the law, just kind of keep it nice and simple. It's possible the council leader will ignore it. You don't, the council leader's not going to necessarily do anything useful. It just maximizes the chance of getting a good outcome now, but it doesn't guarantee it. So what's probably going to happen is you're going to have to trundle through the whole complaints process, then go to the local government ombudsman, and that it may well be that the LGO give you a decision which says, yep, it was, you were right all along. The council leader shouldn't have said that. The housing options team shouldn't have said that. Maladministration, here's your, £1,500 compensation or whatever. So that's as I say, the leader of the council would simply be going on what they've been told by the housing officers. Basically, I mean, you can compare it to Birmingham. So Birmingham for years have been housing families with children in B&Bs for more than 6 weeks. They did have like 750. It's gone down again now. And I think part of the reason it's gone down again is the local government ombudsman has kind of basically been putting some really big recommendations for compensation on. And they've realised actually it's cheaper if they do in fact follow the law, because there could be a whole string of claims against them. You might see something similar happen in Milton Keynes, where they might be saying, well, we don't care what the law says, we're going with this because we haven't got any housing. But when the LGO starts slapping a few four-figure compensation claims on it, and it maybe gets a bit of press, they might change their approach and actually try and follow the law again. So councils do this because they've got away with breaking the law for so long that there's just no real kind of currency in following the law until you start putting it back to them and kind of get these kind of complaints upheld. I'm certainly not aware of any organisation in Milton Keynes which there used to be a shelter there, like a shelter advice service, like 10, 12 years ago, but that's long gone. So there's probably not any charities or anyone useful kind of actually challenging Milton Keynes Council, so they just got away with it, and that's what you're working with really. But the LGO will see it in black and white terms. So yeah, cool. Any other questions, guys? If not, we'll call it a night. Cara, Shannon, and Will, thanks very much for your time. If there are any further questions tonight, come on the live stream on Monday on Will's channel. See you there. If not, I hope this has been useful. As always, I've got a video coming up which is about making a subject access request. I'll go into a bit more detail about it all. But yeah, other than that,